ADA Love or Assistant DA Simone Hilton informed Lil Woody that there were over a dozen defendants left to try. What? Y'all see how long it's taking for them just to get through a few. He could be in there until 2025, 2026. This is a look into what happened behind the scenes in the secret meeting. All right. So this is the motion to recuse Judge Glanville. And there's a lot going on in this filing. All right. So we're going to get into it. We're going to check it out and see why they're saying that Judge Glanville needs to be removed from this case immediately. Now there's 15 pages. We're not going to go through all 15 pages. I'm just going to highlight some of the sections that give us information and insight into what went on in this ex parte or secret meeting. All right. So this is the state of Georgia versus DeMonte Kendrick. All right. Check this one out. Motion to recuse Chief Judge Glanville. The defendant, Mr. Kendrick, by and through his undersigned counsel without waiving any other rights to which he is entitled, files this motion to recuse Judge Glanville from continuing to preside over the present case and requests the present trial be temporarily halted until the present motion is heard by another judge of the Superior Court, consistent with the uniform rules the Superior Court judges of Georgia. That's crazy, y'all. So, man, I feel so bad for these jury members. Some of y'all know I served on a grand jury here in Fulton County in Atlanta for 3+ months. It was an amazing experience to me. But when you're serving on the grand jury, those days that you serve, they're gone. So these jurors have been working on this case for what, 2+ years now? And now you've got this motion to recuse is put in place. It's just delay after delay after delay. And these jurors, man, I'm sure they're probably sick of this at this point. Anyway, it is vital to the functioning of the courts that the public believe in the absolute integrity and impartiality of its judges. Do y'all believe that Judge Glanville is impartial? What? You have to tell me. The present case involves a 65 count. Okay, we know all of that, which is good. Let's see. Central figure, perhaps the central figure in the state's case, is Lil Woody. On Friday, June 7th, we know what happened. Lil Woody was sworn in despite being warned by Judge Glanville that incarceration may be the result of refusing to testify after being given a grant of immunity. Lil Woody refused to testify on that day. Okay, so we know about this. And then he got thrown in jail for the weekend. And then we come back on Monday. All defense counsel were present in the Fulton County Courthouse around 8:30 a.m. So they got there early, man. They were ready to go. They're admitted entrance into the courtroom 1C and everything was good. They were waiting until 9 o'clock, right? All right, so we keep it moving. Defense counsel waited and waited between 11 a.m. and 11:30. So 2 to 2.5 hours before or after the trial was supposed to begin, Glanville took the bench and announced that Lil Woody was prepared to testify. They said, what? Why did this happen? How did this happen? Let's see. Attorney Brian Steele, counsel for defendant Young Thug, inquired with the court as to the delay. He said, what happened and what had occurred prior to Glanville taking the bench? His inquiry was not accepted. I wonder why. Unknown to any member of defense counsel during the waiting period in the morning, upon information and belief, an ex parte meeting was held in Chief Judge Glanville's chambers on June 10th, 2024. And that is a no-no. Can't be doing that. And who was there? Judge Glanville was there. Assistant District Attorney Love was there. We got Simone was in there too. Miss Hilton, Assistant District Attorney Hilton was there, and other members of the Fulton County District Attorney's Office, deputies, sworn witness Lil Woody, and Lil Woody's attorney, y'all. You can't do that. They had a whole picnic out there. I mean, they had everybody. It was a family reunion. It was a prosecution family reunion. They had the judge, they had this district attorney, they had Lil Woody in there, they had his attorney, but no one from the defense. Can't do that, man. No member of the defense counsel was present at the ex parte meeting. All right. Despite the subject matter of the meeting being a critical phase of the trial, especially if they're trying to get Lil Woody to testify, right? Upon information and belief, neither Judge Glanville nor any member of a court staff nor the Fulton County District Attorney Office made any member of the defense counsel aware of the ex parte meeting, either before the ex parte meeting was held, during the ex parte meeting, or after the ex parte meeting. Now, this is interesting because we still want to know. I mean, I want to know, Judge Glanville wants to know why and how Brian Steele found out about this meeting. So it says here, upon information and belief, neither Chief Judge Glanville nor any member of the court staff nor the Fulton County DA, okay, so it wasn't them, made any member of the defense aware of the meeting. Meaning there's only a few people it could have been. It could have been Lil Woody, or as it said earlier, who was there? Lil Woody's attorney. Uh-oh. So it could have been one of those two. I'm going to let y'all decide and guess who you think it was. I have a feeling at this point that it was his attorney, because she was about to get fired. So she's, hey, whatever. I don't care about this. I'm out of the case. She was probably walking by in the hall. And Brian saw her. He said, hey, what's going on? She said, man, we just got out of this meeting with the judge. Brian said, oh, yo, hold on, what? He said, yeah, I was there. The assistant DA was there. Miss Love. Simone Hilton was there. The assistant DA. Lil Woody was there. The judge was there. And he basically said what we're going to hear about here next. Y'all, this is wild. Lil Woody briefly testified prior to lunch recess. One or more members of the defense counsel were later made aware of the meeting with sworn witness Lil Woody and made aware of at least some of the content and subject matter of the ex parte meeting. Oh, Judge Glanville's got a mole. That's why he wants to find out who it is. Upon information and belief, the following events occurred at the ex parte meeting with sworn witness Lil Woody in the chambers of Judge Glanville. All right, so here's everything that went down inside the secret meeting. Y'all look at this. Upon information and belief, and I'm going to skip the upon information and belief just because it gets annoying to say over and over. Lil Woody announced that he would invoke his Fifth Amendment right to testify. All right, he says, I'm not saying anything still. Now, remember, he got locked up on Friday. Right, they brought Judge Glanville, let him out on Monday, and now they're meeting before the trial on Monday. So Lil Woody, he says, I'm still not saying anything, Judge. I'm tired of snitching. I'm not snitching. Lil Woody stated he would sit in jail for 2 years rather than testify. Okay. We got to give Lil Woody some loyalty points for that. All right. Judge Glanville informed Lil Woody that he could keep Lil Woody incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. This sounds like a threat to me, y'all. I don't know. You'll have to let me know what you think. This sounds like he's threatening him to me. But hey, if you don't testify, I'm going to keep you here as long as I want to. ADA Love or Assistant DA Simone Hilton informed Lil Woody that there were over a dozen defendants left to try. What? Y'all see how long it's taking for them just to get through a few. He could be in there until 2025, 2026. Following the above coercive actions, very specific with the wording here, by Judge Glanville in conjunction with one or more attorneys from Fulton County DA's office, sworn witness Lil Woody stated at the ex parte meeting that he would testify. All right. So he says, all right, I'll testify. I don't want to be in jail for that long. Man. Glanville also presented the witness with the printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte meeting. So he let him know what he was getting into here. And then what did Lil Woody said? Lil Woody said to ADA Hilton, Simone Hilton, that if he called to testify that he would lie on the stand. Okay. And what does Simone say? Lil Woody's response to the statement that he would lie. Oh, okay. In a response to Lil Woody's statement that he would lie, Simone Hilton said that she would not prosecute Lil Woody if he were to lie on the stand. What? What's going on, y'all? This legal system is just crazy. That you have the power to enable a key witness, not without the defense being there, to lie and say, don't worry about it, we'll let it go. This is, imagine what goes on that isn't on TV. Sworn witness Lil Woody also stated to Simone Hilton that he would testify that he killed Big Nut. Uh-oh, she wasn't expecting that. What'd she say? She said, hold on. In response to what Lil Woody said, ADA Hilton said that if he testified that he killed Big Nut, then Lil Woody, then she would prosecute Lil Woody for perjury if he testified that. During court on the afternoon of June 10th, which was Monday, when one or more of the above allegations were presented to the court by Attorney Steele, Judge Glanville denied that one or more events above relayed to him were accurate. So that judge is up there lying. Judge Glanville, you got to go, man. I don't know when it's going to happen. I don't know if it's going to happen, but they got to get this man out of here. The judge must cease to act and must make an immediate determination. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that is proved would warrant the assigned judge's recusal from the case. All right. So I'm not a professional on this, so I'm going to let somebody else address that. But basically it's saying they need to make sure that he has enough time and he has to take the time to look at it and needs to remove himself. But Judge Glanville said he's not doing that. The presented motion for recusal is being timely submitted to the court. So they're saying, hey, we gave you enough time here. You should be able to remove yourself, and we need to get another judge in the building. The present motion includes a sufficient affidavit demonstrating the need for recusal. Obviously, we saw above that he was intimidating a witness. I mean, we all know that's wrong. You can't be out here threatening witnesses, man, no matter who you are. And then also the recusal is based on facts alleged in the Weinstein affidavit. All right. So here's them stating all of the rules and the legal side of things. Given that the facts as alleged must be assumed to be true, the Weinstein affidavit is sufficient and the recusal would be authorized under the alleged facts. Another judge should be assigned to hear this motion to recuse. Because right now, Judge Glanville is hearing it and he said, nah, I don't think you got enough here. We're going to keep moving on with this trial. So y'all got to let me know what you think. Is this trial in jeopardy? Is it going to get thrown out? Is there going to be a mistrial? Is Judge Glanville going to be removed from the trial? And should he recuse himself? I think so. Y'all let me know what you think in the comments.